right, my name is Johnathan Ball, and I am employed with the Hidalgo County District Attorney's Office. I am the border crimes prosecutor, and what that means is several years ago, the Texas legislature, they started taking notice of down here on the border. They believed that we were having issues with crime, and so they established a prosecution unit that is with the governor's office. And so what happens is we are given funds in Hidalgo County and in other border regions where the local criminal district attorney is able to hire additional. And so my particular role for the Hidalgo County District Attorney's Office is of drug cases, of trafficking cases, and money laundering cases, which is something that keeps me busy. I'm sure you've been hearing about this all day, the difference between trafficking versus smuggling. It is something that after spending years as a criminal defense lawyer, if you had asked me this question 6 months ago, I wouldn't have been able to tell you the exact difference. I have since learned smuggling is different from trafficking in that smuggling is a violation of it is an issue of bringing somebody across an international boundary for the purpose of crossing them over without doing it legally, whereas trafficking is a crime against a person. And I'm going to talk a little bit about why trafficking and smuggling oftentimes wind up being synonymous or at least intimately intertwined. When we talk about smuggling, we usually think of the Border Patrol agents. We think of the wall, Donald Trump, and making it 30 feet higher. He's a jackass. But one of the things to know about smuggling is smuggling quickly can turn from an issue where people are trying to come over here more often than not, substantially more often than not, to try and find employment, to try and do something that is meaningful with their lives, to cartel violence. And in the process of being smuggled, they end up being trafficked. And how do they end up being trafficked? Well, here's an example of somebody that was just recently indicted, a case that I was working on. There was a lady who paid a smuggler to cross her over from Mexico. She was brought over with a group. She was placed at one home. Some of the overseers of the organization that were involved in the smuggling, this gentleman, went over to check in on the folks that had been smuggled. And in the process of so doing, this man had seen the victim. And when everybody left the house and was taken to the next stash house, he called ahead to that stash house and said, "Wait a minute, there's a lady there," and he gave a description of her, said, "I want her brought back." So she was held for several weeks, explained to the police that she was held against her will, and in the process of being held against her will, she was forced to have sex multiple times, and he was subsequently indicted when she was able to escape from the home, was found on the side of the street, flagged down a sheriff's deputy, and said, "Wait a minute, I need to tell you what's been going on." She was able to explain with good certainty where she was able to provide very good descriptions of the house where she was at, gave a detailed account when she refused to engage in any more sex with this man that she ended up getting her pinky broke, and there was physical evidence from the medical examination that went into this when she was subsequently looked at that substantiated what she said. So, and ended up being indicted recently and is going to be set for trial here before too long. He was charged with 3 things. He was charged with aggravated sexual assault. Sexual assault becomes aggravated when you on someone, and in the process of so doing that, you threaten them with serious bodily injury or death, such as he did with this lady, saying, "I will kill you," or you pull a gun on them and threaten them that way. It can be done either way, in which case it becomes aggravated. He was then charged with kidnapping, and this is the actual indictment, the charging instrument that the grand jury signed to indict him. And then he was charged with 1 count of trafficking as well, because she was forced in to, in this case, labor, which was sexual services, that she never signed up for. That wasn't part of the bargain. She thought she was coming over here to do work that didn't involve sex, so he was indicted on those 3 counts. Historically, human trafficking has been something that the federal government has always taken the lead on. And the federal government has always taken the lead on it because, A, it generally involves smuggling and involves breaching international boundaries, and B, it usually involves something that has to do with interstate commerce. The way that the federal government is able to regulate so much of what they do, that they need to regulate interstate commerce, and so they're able to criminalize a lot of activities. Texas decided not too long ago that they needed to get involved themselves, that the federal government wasn't doing enough, and they decided that they wanted to get actively involved. And House Bill 10 was the first step in getting involved. For a long time, prosecutors have had tools at their disposal. The tools of indicting for aggravated sexual assault, indecency with a child, continuous sexual assault of a child, kidnapping, unlawful restraint. Those of us that have been either on the prosecution or the defense side of the law understand these types of charges, have either defended or prosecuted them multiple times. But what the Texas legislature wanted to do is they wanted to carve out a set of laws, a set of crimes that dealt specifically with human trafficking. And these individuals, one of whom is local, Oscar Longoria, crafted this legislation, House Bill 10, that gave us additional tools. For instance, it added something about compelling prostitution. One of the issues that comes up in trafficking is the compelling of prostitution. And what the Texas legislature did is they moved the offense level up. They have now made it a first-degree offense, which is an offense that, if you're convicted, carries a minimum 5 years, up to 99 years, or life in jail. And when I say up to 99 years or life, I've asked many judges to explain the difference between why it's up to 99 or life, and nobody knows, but that's the language they've chosen. Just know you can go between 5 and life. Probably more significant than making it first degree in my mind is that they did away with the requirements of the statute of limitations. Most statute of limitations in Texas run around 3 to 10 years, depending on the type of offense. Here, there's no longer a statute of limitations. And there's a slide later on that I should have arranged on this one that talks about why they decided to do that. Well, they ended up hearing testimony. They took some evidence at the legislature when they were devising this. And what they found out was victims of trafficking are commonly brainwashed. And brainwashing is a very generic term, but it's what we're talking about here. They are told that if they tell anybody, they're going to wind up harmed, their family will wind up harmed. They themselves develop their own issues relating to mental illness, to narcotics use, alcohol use, dissociative disorders, whatever type of psychological needs they need to fulfill, they end up developing those as protective mechanisms. So they may not want to disclose these things. They may not want to talk about these kinds of things. So until they get the help and they decide that they're going to talk about it, nobody can be prosecuted, but now there is no statute of limitations for it. If we're going to talk about trafficking, we need to know some basic definitions. One of the speakers was up here was talking about prostitution being legal, or at least people turn a blind eye. I would beg to differ that it is legal insofar as if you looked at the monitor, there were somewhere in the neighborhood of 16 men and women that were arrested recently, not too far from here downtown, and they were charged with Class A misdemeanor. So the fact that prostitution is a Class A misdemeanor as opposed to a first-degree felony or what's called a super felony, which is 25 years to life in jail, tells you there is a sense that when it's two consenting adults, maybe there's a little less harm that goes into it, for lack of a better term. Maybe it can be viewed as somewhat victimless. I wouldn't necessarily agree with that, but I think there may be some views with that in society. And so if we're going to talk about prostitution, what you need to know is that it is the offer to exchange money for sexual favor or something of value for sexual favor, or you can actually have somebody go and broker the deal for you. If somebody goes and says, will you please engage in sexual conduct with my significant other, my friend, whoever it is, in exchange for money, is prostitution. Compelling prostitution. Now moving up the food chain onto what is the more serious offense. Compelling prostitution is one of the new charges, the new heavy-hitting charges, which is if you use force, if you use a threat, or if you use fraud, basically deceit, in order to get somebody and compel them into prostitution, you are committing a second-degree felony. A second-degree felony carries a range of punishment up to 2 to 20 years in jail, and you're required to register under 62 of the Code of Criminal Procedure, and that is the dreaded sex offender registration. As a criminal defense lawyer, I can tell you when I was doing that, people were more afraid of sex offender registration than they were of doing 3 years in the state penitentiary. The sex offender registration was something that just scared the life out of them, and so it serves a purpose as a deterrent, but it's also what society has, particularly the ones that are categorized as high-risk offenders. People need to be given notice of where they're at. Under Section A2, a person commits compelling prostitution if they have somebody younger than 18 years of age become involved in prostitution. There's several differences that are key to note from Section 1 and Section 2. If it involves a minor, there is no need that you threaten the minor. There is no need that you compel the minor, that you force the minor. The reality is the minor cannot consent in any way, and you don't need to even know that that person was a minor that you were pimping, and I'm not a fan of that word, but just for lack of a better term, if you are the person, the actor that is pimping the person under 18 years of age, you don't need to know that they're under 18. So long as they are 18, you committed a first-degree felony or life, and you're in deep trouble. That's what I was talking about. No need of threat, coercion, fraud, force. Locally, just a few days ago, this hit the paper. This is a file that is on my desk currently, so it was on my mind, and I'd share it with you guys. This is all public information, by the way. I'm not telling secrets out of school. These two individuals were arrested when two girls, about 14 years of age, were found on the side of the road. And these two girls were able to tell the Edinburgh police officers who investigated this case and the investigators and give very good details of where they had been taken to, of how it was that they were trafficked, which was placed in the statements that talked about these two individuals drove to Louisiana and picked up these two young ladies. After bringing them back from Louisiana to South Texas, they set up on various social media outlets, including Backpage, a few other spots, and began the process of trafficking them. And they testified that they gave statements to the police that they had been taken to several areas locally where they had been prostituted. And in exchange, they had received money and were required to give money to the defendant and his wife in order to have food, in order to be able to stay in the home. Ultimately, they were sent on the side of the road. The police were able to find them, and doing some very good investigative work, they were able to get access to them. This was the slide that was out of order. This talks about why it's important that the 10-year statute of limitations has now been removed, because we get what are called delayed outcries, where people just say, you know what, I'm not going to deal with this. I'm not going to dredge this past back up. I've put it away. I've moved on with my life. Well, at some point, oftentimes people will decide, you know what, I need to deal with whatever these issues were, and they go and they make the claim that they were trafficked many years ago. Well, the statute of limitations hasn't run, and people can still be brought in and prosecuted for it. There's the crime victim. The Texas Attorney General's office has more money to be able to get counseling, to be able to compensate victims, to be able to get them the additional help that they need so that they are able to get back on their feet, that they're able to hopefully move past this and deal with whatever issues they have. The sex offender registration, the dreaded sex offender registration, we have expanded the list. The legislature expanded the list of offenses that are going to require people to register as sex offenders. Depending on who you're talking to, that's a dual-edged sword. I happen to believe that that is a good thing. They're going to begin placing people who are compelling the prostitution, not just those that are actively engaging in it, but those that are compelling it. They're going to place them on the registry as well. The governor's office is now requiring local school districts to training their teachers and their counselors, their principals, their staff, how to identify who is being trafficked and how to look at somebody and say, I think that there's a situation here that isn't right. They're being told what the signs are, the symptoms, so to speak, how they can identify how and who they report these cases to, the hotlines that they're supposed to report it to. Under the Texas Family Code, teachers, nurses, doctors, lawyers, judges, anybody that has knowledge that child abuse has occurred is required to report that they believe that this child abuse has occurred. And they're required to file a report. And now what has happened is that the teachers in the school districts are required to get training in how to do it. Judges themselves, they're going to have to get more training. We'll see where that goes. And Human Trafficking Task Force. The Human Trafficking Task Force was set up, and what they do is they make a report to the legislature every year. And I printed up a copy of it, and I started reading it over sometime back as I was prepping for this. It was the first time I had read it, and it was filled with a lot of information that even after years of being involved in law and handling these kinds of cases, I didn't know. Lots of good statistics about the number of people that are involved, the percentages of the folks that are involved, what kind of various industries that they're involved in, either through what are called SOBs, sexually oriented businesses, or whether or not it's legal fronts for businesses, restaurants, bars, a massage room, and I'm certainly not trying to give masseuses a bad name, but that is something that we do see from time to time. And so they enacted this legislation where they have to give these reports. This is the cover page of the report, not real fancy, but filled with great information. Two takeaways that I was particularly interested in is the use of the social media. The social media, it allows a degree of anonymity. It allows very quickly for people to be able to contact one another, to set up the meetings so the meeting is arranged quickly. You go, the act occurs, and you're gone. However, in the process of that happening, oftentimes, as you'll know, there are traces that are left. There are traces that are left where the GPS on the phone, if you're able to get somebody that's involved in that, be it the young lady, for instance, that were just picked up, be it the husband and wife that were arrested, or if you can get one of the Johns that was actually involved in this and get their phone, you can start down where they were, who was involved. So if you get the cell phone from these two individuals that were arrested, and you're able to download that information and see what's in there, you may very well be able to actually start pinpointing, well, they checked in here, they were over here, we know that phone calls were made here, and the text messages were sent here. And that's when the investigation really starts. It's not just knowing that these two people that were compelling the prostitution are off the street. It's also taking that information and beginning the process of really unpacking it and trying to figure out who it was that was involved. Early intervention measures. I'm a big proponent of treatment. I'm a big proponent of not just the jail side of it, but making sure that we get people the help that they need so that hopefully you find a way to stop the behavior that got them into it. Minnesota found that for every $1 spent on intervention in trafficking through helping the victims of trafficking, that they were able to save themselves $34. In other words, if they were proactive, if they decided, you know what, we're not going to prosecute the women generally that are involved in this, we're not going to charge them with those offenses, and instead what we're going to do is we're going to try to help, we're going to try and rehabilitate, we're going to begin viewing them as victims, and that may very well mean that we set them up in an apartment, that we give them some sort of subsidies until they're able to get gainful employment, that by doing that, they're saving themselves $34 for every dollar that they invest, and that goes back to, it's about $40,000 a year to house somebody in jail. Then you have to give them the medical care while they're in jail, and then it becomes a cycle, and I don't guess that I need to give anybody a lecture on the recidivism rates once you go to jail, the odds of staying out of jail are few and far between. Other tools that the state has at their disposal. In Harris County has taken a very proactive approach, a very almost heavy-handed approach in going after businesses. And I'm not opposed to the heavy-handed approach. But what they are doing is they are going after the strip clubs that are known for compelling or for allowing prostitution. They are going after the sexually oriented business, the SOBs, so to speak. It's apropos. They're going after those organizations, those businesses, and saying, you are allowing prostitution to occur, you are allowing drug sales to occur, you are allowing us to occur. And how do we know that? Because we're getting the incident reports from here. We're looking within a 5-block radius of here, and we're seeing the number of arrests for prostitution, for drugs, for DWIs, for guns, for all those things that are coming out of your establishment. And because of that, we, the city of Houston, believe that you are a nuisance. And because of that, the Texas government code allows the city to file suit to have them declared a nuisance, at which point they're able to either shut them down indefinitely, to shut them down for a year or any other amount of time that a judge thinks is needed or that is agreed to. In this case, it was a bar, a gentleman's club, a strip club called Treasures. And an agreement was reached with Treasures where they would still be allowed to operate, they would still be allowed to stay open, but Treasures would, at expense, hire individuals to come in and to educate the workers, and not just the dancers, but the bartenders, the operators of the business, to make sure access was granted and that education was given, that they would know how to get access to forced labor hotlines, sexual trafficking hotlines, so that they understood what their rights were, working within that realm and what people could legally and not legally do there. And they were also forced to give $100,000 to the city and $100,000 to another organization that dealt with trafficking. So as best I could tell in doing some research on that, that lawsuit and those sanctions that they imposed did have a corrective effect, and it remedied the issues that were involved. There is the Child Sex Prevention Unit that has been created, and one of the new laws that has come out, that came out of House Bill 10, is Section 20A of Texas Penal Code. Section 20A of Texas Penal Code deals with regulations for human trafficking. Under 20A03E, that was where the legislature said, now we're really going to come after you. And what that says is that if a person, the actor, engages in the offense of compelling prostitution, i.e. trafficking, 2 or more times in a 30-day period, and it can be the same victim, or it can be using 2 or more victims. It doesn't matter how you get there, but if they engage in 2 or more activities that constitute trafficking, where you entice, encourage, transport somebody through fraud, duress, or coercion, unless it's a minor and you don't need those things, 2 or more times in 30 days, you have to do 25 years in jail if you're convicted of that. Mandatory minimum 25 years. And so the state is catching up to the federal government in terms of imposing these very, very stiff sentences on these sorts of cases. Recently in federal court, somebody was sentenced to about 26 years for a situation very similar to the one I described involving the 2 young ladies. Here's my favorite part of this whole thing, and this is the legal nerd in me coming out. As a defense lawyer, I would have hated this. As a prosecutor, I love it. Under the Texas Code of Criminal Procedure, which is our rule book, how we try cases, the Code of Criminal Procedure says that a person cannot be convicted on the testimony of an accomplice witness only. What does that mean? That means if myself and somebody else get together and we decide we're going to go and rob a liquor store, and that liquor store doesn't have cameras and nobody sees it, and we successfully complete it and there's no witnesses, and the only person that knows that I was involved was the guy that I went and robbed the store with, or the lady if she's adventurous, the person that I robbed the store with, the testimony of that person alone is not enough to convict me. Anybody know why? Because, that's right, people lie. Accomplice testimony is known to be fraught with danger. People will say and do anything to avoid jail, including lying in court, and we know that. Take a look at the Innocence Project. You'll see constantly people through accomplice testimony. So Texas has said accomplice testimony, you cannot be convicted on it. But if it is a Section 20A case, a case involving sex trafficking, you can be convicted solely on the word of an accomplice. Why? Because oftentimes the evidence will be nothing more than an accomplice in the form of the victim or an accomplice in the form of somebody that has decided, you know what, I'm not going to do the mandatory minimum 25 years. I'll take my second-degree offense. I'll do 2 to 20, and then we'll talk later. Second part that I really like about it. The U.S. Constitution, everybody's heard about it, has the Fifth Amendment. It's the right to remain silent. So if somebody asks you a question, you say, at this point I'm going to invoke my right to remain silent because any answer I give will have a tendency to incriminate me. We had a case recently where some people came in. They said, you know what, they brought in, said, you need to testify. They said, we're not testifying on advice of counsel. Jury never gets to hear what they say, and in fact, the jury never even gets to hear that person invoke their Fifth Amendment right. Notify the judge ahead of time. Well, in federal court, one of the ways that they have always gotten around that is they will get permission, for instance, from the Department of Justice up in Washington, D.C., to immunize somebody. And when you immunize somebody, you tell that person, nothing you say can be used against you for anything. Nothing you say while testifying can ever be used against you in subsequent prosecution. If you confess to killing Kennedy, we can't prosecute you for it. And so that is how you get around that. And once a person is immunized, and once they are told on the record in front of a judge, and the judge approves the immunization of that witness can no longer say, I refuse to testify, because their Fifth Amendment privilege no longer applies because they're not being subjected to criminal prosecution for anything that they say. And that was one of the issues that occurred in the case where there was an ICE agent that was shot out in Hargill a couple of years ago, which went to trial, and they had to immunize one of the accomplices, who was the son of the shooter, in order to gain his testimony. And once he was immunized, he had no choice but to talk. So here, Texas has said the same thing. We as prosecutors now have the authority to immunize people. That when somebody says, I'm not going to testify, for instance, the young lady that is 20 years old, who has spent the last 5 years with a guy being trafficked, who has been told that she is owned, that she will be easily disposed of and nobody will miss her, and all those sorts of things. Or conversely, and maybe even worse, feels that she loves this person, that she is attached to him, that he has her best interests at heart. Well, we can immunize her, and she can be forced to testify. Really, the only penalty for not testifying would be a contempt proceeding, which is where you refuse to follow a court order, but that's what we have available. The accomplice witness rule, I already explained that. End result is what the legislature did, what Bill 10 did, is it gave us as prosecutors substantially more tools. It gave us really something to go out and start clobbering people over the head with when they wind up in these positions and they say, well, I didn't know that she was under 18. Well, that's your problem. A, you shouldn't have gotten involved in sex trafficking, but B, you really shouldn't have gotten involved with it with a minor. Or when that person comes back and says, she's never going to testify against me, she knows I own that girl. She's not going to have anything to say. Bullshit. She's going to have a lot to say because we're going to immunize her and we're going to compel her to testify, and she's going to have to. That concludes my presentation, and questions, concerns, comments, criticisms? That's correct. All of this is on the state. There is an impact it will have on the federal side, though. For instance, if these two folks involving the young lady from Louisiana, if they are prosecuted for moving her across state lines and they're convicted in state court, that's going to substantially enhance the penalty that they're going to receive in federal court on federal sentencing guidelines. So, anybody else? Okay. Thank you all very much. Enjoy the rest of the conference.